Our topic for this session is, are we doing enough to protect transgender children? This panel will explore the way the legal system addresses the needs of transgender kids. Is the family court the most suitable realm for determining access to hormone treatment for children? Do current family court processes protect them, or do they inflict unnecessary emotional and physical stress? Also, how effective is the Safe Schools program in making transgender children feel safer at school and in their community? Our first speaker is Dr. Fiona Kelly. She's an Associate Professor and the Deputy Director of the Centre for Health, Law and Society at Trobe University Law School. Fiona's research is primarily on the intersection between family law and health law, and she has a particular interest with the regulation of assisted reproduction. But more recently, her research has focused on the role of the family court in medical decision making for transgender youth. So would you please welcome Dr. Fiona Kelly?
Well, thank you for all coming out this morning to listen to us. As Damien said, I'm going to be talking about the family court process that transgender adolescents need to go through in Australia to access hormone treatment. So at the moment, family court approval is needed for a young person to get access to what I will call stage 2 hormone treatment. And one of the questions that was posed for this session was whether the family court process protects transgender children or whether it actually inflicts emotional and physical stress. And I'm going to answer that question by drawing on research that I've done with families who have gone through the process or who are currently going through the process to hear what their experiences have been. I will give you a very brief background to the legal issues. And the medical context as well. So medical treatment for transgender adolescents and children is regulated by international consensus guidelines. There's a very rigorous process that doctors need to go through in order to diagnose what's known as gender dysphoria and to treat the child. Treatment occurs in 2 stages. Stage 1 is usually comprises the administration of puberty suppressant hormones. They're often referred to as blockers. And that usually occurs when the child is about 10 or 11 years of age, depending on their development. And in Australia, parents can consent to that treatment alongside medical advice, obviously. Stage 2 treatment, which usually occurs when the child is about 15 or 16 years of age, involves the administration of hormones, estrogen or testosterone, that then reflects the child's gender identity. And to access that treatment, stage 2 treatment in Australia, the parents need to seek family court approval. So usually parents can consent to their child's medical treatment. If your child has cancer, you can consent to chemotherapy, etc. But for this particular treatment, parents cannot consent. So in recent years, in the media, certainly we've heard anecdotally about the impact of this family court process on children, on their families, but there hasn't been any systematic research to determine whether what those families have talked about is in fact a universal experience. And so to fill this gap, I conducted an interview-based study with parents of transgender adolescents who had either gone through the court process in 2015 or who anticipated going through it in the next 6 to 12 months. There were a number of themes that emerged from this research. But the absolute universal theme, or the area about which the parents were in total agreement, was that the court process was unnecessary as well as deeply harmful to their family and to their child. The harms identified were multiple, but 3 emerged as strong themes. The one that really dominated the interviews was the psychological impact of the court process on the child, as well as the well-being of other family members. So siblings and parents were also affected negatively. So many of the parents recounted to me stories of increased anxiety, depression, and dysphoria as a result of the court involvement. In all instances, the court process took at least 6 months to unfold. In some cases, it was a 12-month process. And the mental health of the child typically deteriorated as that process went on. So as Jasmine, the mother of a 16-year-old, explained to me, I always said to her, look, it's the system. It's not you. You know, it's nothing to do with you. But as it wore on, and it was just this long timeline, and she's dealing with other teenage stuff, and she became depressed, to the point where I was actually concerned about her well-being and had to take her to hospital. A number of the parents also noted that even the prospect of the court process in the future was taking a psychological toll on their children. So Tessa and Neil, who had a 14-year-old daughter who was likely to apply for stage 2 treatment in the next 12 months, was also experiencing the stress associated with that possibility. So Tessa recalled a conversation in which her daughter expressed her anxieties around the upcoming process. This is what she said to me the other day. She said, I don't think my body actually belongs to me anymore. And that was pretty heartbreaking. Just through this whole process, that's where she's at right now. You know, her own mental image of a court case is To Kill a Mockingbird. I keep saying it's not To Kill a Mockingbird, but there's that sense that it's her own body on trial. The court process also took a psychological toll on the parents. Several of them recounted stories of having their privacy invaded as they were required to repeatedly recount their child's story to different professionals, most of whom had no familiarity with gender dysphoria. So Jasmine told me about her experience of doing an intake interview with a pro bono legal service, for which she was very grateful, but nonetheless the experience was stressful. So she explained, I got a volunteer. I can't remember exactly what she asked me, but I did need to divulge the nature of our case. So already it felt like this process of being exposed to strangers. And it's like, what the hell, you're not a counsellor, you're not a doctor. I was just feeling this burning sense of injustice already. It was daunting and difficult and unfair. The second theme to emerge from the interviews was that the court process caused serious delays in the child's treatment, often jeopardizing their mental health and even compromising the efficacy of their medical care. 3/4 of the families were relying on the service of pro bono lawyers and were nervous about being too demanding. As a result, long periods of time often passed without any update on their case. 2 of the adolescents experienced a failure of their puberty blockers, making stage 2 treatment urgent. For one young woman, the delay was unbearable, and her mother, Pauline, explained, her medication failed and she went into full-blown male puberty in a very short space of time. I mean, it was just horrific and ironic that after 4 years of consistent treatment, we were back in danger of her voice breaking. My daughter went into this terrible dysphoria that she'd never experienced before. I'd never seen her that bad. Her voice is very important to her, and she told me that if her voice broke, she would kill herself. Desperate to get a court date, Pauline contacted her lawyers. It seems it takes a crisis to get people moving, and my daughter's elevated testosterone levels and her dysphoria, my head was about to blow off my shoulders with worry. I got on the phone first thing in the morning, and I'm not usually given to this, but I just wept. I wept, and I walked around the house in this howling state and waited for people to call back. Pauline's lawyers were able to get a directions hearing the following week at which the judge, recognizing the potential catastrophic implications of further delay, made an order enabling immediate access to treatment. The final theme to emerge from the interviews was that the court process placed an enormous financial burden on the families. The cost of proceedings was estimated to be between $8,000 and $20,000. Even with a pro bono lawyer, families often had to pay for reports as well as various court fees. A number of the parents also lost income during the lengthy court process because they had to take time off of work for various appointments, as well as to manage their child's deteriorating mental health. Susie, whose son was 12, was already concerned about how she would pay for the court process, particularly as she was separated from her son's father and anticipated that he might not be supportive. This anticipatory stress of the process was taking a toll on Susie's son. As she explained, the other night he came out of his bed crying and said, "Mum, what happens if you die before I go to court? How will I get this? What happens if something happens to you?" You know, he's aware that steps need to be taken and it costs money, and I guess he's aware that I'm his advocate. And what happens if I'm not there? For some families, the court costs were simply insurmountable. Pauline, who ran a support group for parents of transgender children, indicated that she knew some families who were simply waiting until their child turned 18 and could consent to treatment themselves because the cost was something that they could not bear. So this research suggests that the legal status quo is doing little to protect transgender adolescents and plenty to harm them. And at the moment, there is no end in sight. The Chief Justice of the Family Court, Diana Bryant, indicated in an interview in November 2014 that she would welcome a High Court challenge to the current legal position, though of course that would involve a family pursuing the matter to the High Court. But in the meantime, she would streamline the Stage 2 application process so that it could at least be cheaper and more efficient. But 2.5 years later, the system remains completely unchanged. Stage 2 decision-making still requires a full hearing, and no family has been willing to take their child to the High Court. Pauline, who went through 3 family court cases for her daughter, was outraged by the suggestion that the responsibility for changing the system rested on the shoulders of the families. As she explained, "When we decided not to do another appeal, I felt this enormous sense of relief that the burden had been lifted from our family. And then I felt this fear that the families coming behind us were completely naive and innocent. It was like they were succumbing to something unhealthy, and I hadn't been able to prevent it." This is an area that clearly deserves law reform and increased attention from politicians who are in a position to make the legislative changes necessary. However reform is achieved, though, it's clear that removing barriers to accessing Stage 2 treatment will enhance the emotional and physical well-being of Australia's transgender youth and support their families through the process. Thank you.